This is an appeal in the matter of Randhawa and the Secretary State for him.
My lords, my lady, I appear for the appellant this morning. My learned friends, Miss Smythe, KC, and Miss Elliott appear for the respondent. My lords, my lady, the appellant is a citizen of Pakistan. His brother is a citizen of Italy. In 2017, the appellant joined his brother in Italy as a dependent family member. He was issued with a residence card on 3rd of February 2017, valid until 2nd of November 2022.
By the Italian authorities?
By the Italian authorities, indeed, yes. In 2019, the appellant's brother decided to move to the UK, and the appellant accompanied him. They both arrived at Manchester Airport on 12th of December 2019 and sought admission. An immigration officer examined their passports and the Italian residence card and said to them, quote, "You can go," end quote. They thereby entered the UK. They both then made applications for pre-settled status under the EUSS. The appellant's brother was issued with that status. The appellant's application was refused. And these appeal proceedings arise from the latest refusal of his application. This appeal raises two questions. The first question is whether the appellant falls within the scope of Article 10.2 of the withdrawal agreement. And the second issue is whether the appellant is entitled to the new residence status under Article 18.1 of the withdrawal agreement. And I shall seek to persuade you, my lords, my lady, that the answer to both these questions is yes. Subject to any observations, I will address you on two questions in turn. So the first question, the scope of Article 10.2. In my respectful submission, the starting point for consideration of this question is this court's judgment in Vasa. Now, I accept at once that Vasa does not decide the precise questions that arise in this appeal. And the facts are different in one aspect. However, in my submission, Vasa sets out the path that would, in my submission, lead the court to the correct answers. That authority is behind tab 17 of the authorities bundle. My lords, my lady, will see that the applicants are Albanian nationals. They presented at the United Kingdom border before the end of the transition period in order to enter and reside with a sibling who was a national of an EU member state. The immigration officer stamped their passports with the words "admitted to the United Kingdom" under the regulations. Of course, that is the material distinction. And they then made applications under the EUSS. The Secretary of State refused their applications, and the issue before the court was whether they fall within the scope of Article 10.2.
Before we get on to that, are you abandoning the argument that he entered under Regulation 11, which was something that we discussed at the Commission hearing? Did he or didn't he enter under Regulation 11? Well, come back to that, but at some stage we need to know, because that's what the Upper Tribunal decided.
Yes.
Yeah. Anyway, you go back to Bass and come back to that if...
Absolutely. So, my Lord Justice Lewis, at page 651, paragraph 9, summarized the system prior to the end of the transition period. And my Lords, my Lady will see Article 3 of the directive set out at paragraph 12. This relates to other family members, as the court knows. Family members who are dependents or members of the same household. That is point 1. Point 2 concerns a partner in a durable relationship. Paragraph 13 makes the point that there is no automatic right of entry in relation to extended family members. By Article 3.2 of the directive, the member state had to confer certain advantages on the applications made by such individuals, and that the member state had a wide discretion as to the factors to be taken into account. So ultimately, the point is that whether a person is to be admitted and allowed to reside in the UK as an extended family member is a matter of discretion of the member state, discretion being a wide discretion. If you look at paragraph 14, my Lords, my Lady will see that there is reference to the 2016 regulations, Regulation 7 and Regulation 8. Regulation 7 concerns family members. Regulation 8 concerns extended family members. But Regulation 7.3 says that if an extended family member is issued with an EEA residence permit, then that person must be treated as a family member as long as they satisfy the conditions. Of course, not my
We don't
case.
have an EEA family permit here, do we?
No.
And the residence card that the judge, well, I was the judge, was referring to there, was the residence card issued in accordance with the 2016 regulations. It wasn't intended to be a reference, was it, to an Italian residence card? Because that's not what the regulations define a residence card as being.
Yes, so the Italian residence card is not a residence card that it is not an EEA residence card that is referred at Regulation 7.3.
No, it's the British one. Yeah.
It is the British one indeed, yes. So Regulation 7.3 says that provided that extended family members issued with EEA residence permit or residence card, if it was Italian residence card, then there wouldn't have been a problem. But the problem for me, of course, is that the residence card is defined as a residence card issued by the UK authorities.
Yeah.
For Regulation 7 purposes, it has to have been issued by the UK authorities.
Yes.
So we're all agreed, are we, that whatever the applicant, the appellant was holding, it was not a Regulation 7.3 document?
No,
Great.
absolutely. You then have a heading just above paragraph 15, the provisions of the withdrawal agreement. And under that heading, my Lord Justice Lewis refers to Article 9 at paragraph 16, which concerns family members and indeed extended family members who are not family members within the definition. And you then have paragraph 17 reference to Article 10. That article defines who falls within the personal scope of the withdrawal agreement. And Article 10.2 and Article 10.2, 10.3 are referred to at paragraph 18. So it's Article 10.2 that is relevant. My Lords, my Lady will see that that provides, that relates to persons falling under points A and B of Article 3.2 of the directive, which Here is the appellant. The appellant fell within point A of Article 3.2 because he was a dependent family member of his Italian national brother, and he was a member of his household. So there is, in my submission, no doubt that the appellant is a person who fell within point 1 of Article 3.2 of the directive. The next...
Hold on a minute, we just need to check. Can we just check that? Because you're taking us through the case. I'm looking at Article 3.2 itself. Of the directive.
Of the directive, indeed. Which is quoted in the judgment, lady, if it assists. So it's quoted at paragraph 12.
Okay.
It's quite useful to look at the directive because it makes things clear. It's at tab 3, page 127.
Yes.
Article 2 gives the definitions,
Yeah.
and page 128 gives family members, which is the spouse and direct and descendants. And Article 3, they had it beneficiaries. We call it extended family members, but they're the same.
Mm-hmm.
And it's other family members who are not in the Article 2 one.
No.
Yeah.
Indeed. So the question for the purposes of Article 10.2, I mean, of course, the first question that would not get me home, but the first question is whether the appellant is a person that falls within point A of Article 3.2. The answer is yes.
Well, he's capable of it because he is another family member. Then
Yes.
there would be the question of dependency.
Yes. A dependency or my lord, membership of the same household.
Yeah.
There is no dispute. There is a finding that they were a member of the same household at the time of the application.
Okay.
So there's no doubt, therefore, that he is a person who falls within point A of the directive. The controversial question concerns the next part of Article 10.2, which is whether the appellant's residence was facilitated by the host state in accordance with its national legislation before the end of the transition period. The issue before the court in that case was when the immigration officer admitted the appellants into the UK, whether that was a facilitation by the United Kingdom in accordance with its national legislation of those appellants' right of residence.
Hold on. You've introduced a concept of a right of residence. There isn't a right of residence.
There isn't, yes.
That's the problem.
No.
They don't have the right of residence. The question is whether their residence has been facilitated.
My lord is absolutely right, yes. No. My lord is right, absolutely. So that was the issue before the court. Now, if you then look at paragraph 20, my Lord Justice Lewis, there quotes from Article 18. It concerns the second question. And why is it that extended family members fall within Article 18? My Lord explains that at paragraph 21. The purpose of Article 18, and this is the purpose that I would respectfully invite my lords and my lady to bear in mind in considering the arguments. The purpose of this article is to ensure that the rights of residents of EU nationals and their family members, which are guaranteed by Title 2, are reflected in the new status document, new residence status and documents issued evidencing that status. So that is the purpose of the article, that if a family member has a right, then that right is to be reflected in the new status. But why is it that it applies to extended family members as well? Because this is just above letterhead. They are, however, clearly intended to be within the scope of the resident status. That appears from the fact that the status applies to union citizens, family members, and other persons. Other persons. My Lord is saying in my submission that, of course, there's a difference between family members and extended family members. My Lord is saying that, well, other persons include extended family members. And that is how this applies also to extended family members. If you then go to the analysis, first to the submissions that were made to the court.
Pause there. Is it right to say, I'm just making my notes,
Yes.
is it right to say here that Article 18 is apt to include extended family members? My Lord says so at to H, paragraph 21. But that we have to remember that Article 18 is all about people who've got rights of residence. So
Indeed.
if you're an extended
Absolutely.
family member with a right of residence, you're captured by Article 18. But
Yes.
just because you're an extended family member doesn't
No,
mean anything more.
no. Hence, there are two questions in this appeal. And persuading you to answer the first question
Yeah.
does not assist unless I also persuade you to answer the second question in the affirmative.
Because being within the scope of the agreement is very interesting, but it doesn't do anything. It's
Yes,
being entitled to within the scope for the
Yeah.
purposes of getting the resident status.
absolutely. Absolutely. Now, if you then go to page 661, and if you see the heading submissions, you'll see that the appellant's argument was rather straightforward. That it was not the case that the residence would have been facilitated only if the appellant had applied for a family permit or residence card under the regulations. The argument was that when they presented themselves at an immigration officer and the immigration officer admitted them into the UK, that was facilitation of residence for the purpose of Article 10.2. That was the facilitation, and facilitation does not mean the UK residence card. The Secretary of State's argument is set out at paragraph 82 onwards, and my learned friend Ms. Smythe makes 3 submissions in that case, and in my submission she makes the same submissions in this case.
I mean, in that case, the claimants were saying, look, we've got a decision saying we've been admitted under the regulations. And then there was a question as to what that meant. And Ms. Smythe was saying, oh yes, but they shouldn't have done that. They made a mistake. They were very silly immigration officers.
Yes.
They should have put the stamp back in the drawer. And the question was, firstly, what did the decision mean? Was it actually a decision to facilitate their residence? And secondly, if so,
Yeah.
could it be undone because they shouldn't have used that stamp in the first place?
Well, same arguments are made here.
Yeah.
My learned friend says that when the immigration officer said, you can go, the immigration officer made a mistake.
But the first question is, what did the immigration officer mean when
Yes.
he or she said, you can
You can go.
Because we know more about the Vassar facts, because we know 2 things. We know that the officer used a stamp which said admitted,
Yes.
and
Yeah.
the reasons or the things under which the person was admitted, and whether or not that was erroneous was another question.
Yes.
Here, you've got, you can go.
Yes. Well, what does that mean? Of course.
Exactly.
Yeah. So the court will decide that, and the court will also
Could
decide.
mean you've got leave to enter. Maybe nothing to do with residence.
Yeah, I understand that. My Lord, so three submissions are made by my learned friend in that case. The first submission is at paragraph 82.
52.
82. No, my apologies.
There isn't an
milady.
82
No,
in
no,
this case.
52, milady.
Yeah.
My apologies, 52. So the first submission is that facilitation means issuing of a residence card, issuing of a UK residence card, not simply admission by an immigration officer. That is the first submission. The second submission is at paragraph 53. The same submission my learned friend makes here, that the immigration officers had no power to admit the appellants in that case under the regulations. And they made a mistake, they made errors of law. And the third submission is at paragraph 55, which is that they, in any event, were only admitted into the UK. Admitting them does not mean right of residence. That simply means admission. Now, these competing submissions are considered from paragraph 57 onwards. And my Lord Justice Lewis says at paragraph 57 that the starting point is to consider what the immigration officers did on that day. On any reasonable interpretation of the available evidence, they presented themselves at the border, wanting to express, wanting to be allowed to come to the UK, and they were admitted, and a stamp is placed, admitted to the United Kingdom under the regulations.
Well, there are three things in that paragraph. One, there's a statement as to what those particular people were to be taken as wanting to do, and you'll want to address us about what's the evidence that this brother was intending to come to live with, i.e. that the immigration officer knew that the brother wanted to come and live with the brother in England. Secondly, there's a decision being taken by the officer that they were going to be admitted. And then thirdly, there's evidence as to what that decision was, because you've got the stamp, and that will tell you a bit about what was in the mind of the immigration officer. So there's three stages. What was happening when they turned up? What did the immigration officer do? And what's the evidence of what he had in his mind?
Yeah, so the answer to the first question in my submission is that the appellant comes to the UK with his brother together. And as my Lord pointed out in that paragraph, they simply presented themselves to be allowed to come and live in the UK.
Well, where's the evidence that that's what they did? Where's the evidence that they said, we're coming together to live? I mean, do we even know what the brother said to the immigration officers? I mean, you can come with your brother for lots of purposes, to visit him, to go sightseeing.
So the evidence, my Lord, is that they both arrived in the UK at port. They presented their passports and residence card, and they were told, you can go. There is no evidence that they said anything to the immigration officers. There are two witness statements if you wish to see them, but this is what it really comes down to.
So the first fact is there's no evidence at all that the immigration officers were told that the appellant was coming, or well, either that the brother was living here or was coming to live here, and the brother wanted to come and live with him too. There's no evidence that that's what the officer was told.
Yes. I, of course, accept that. The submission that I make is that, for the reasons that I will explain, is not fatal to the argument that I make. That the point being that they both presented themselves, essentially expressing a wish to enter into the UK.
Well, you certainly knew they wanted to come into the United Kingdom, otherwise they wouldn't be on a plane to Manchester. The question is, why were they coming to England?
Yeah. So they say, of course, that their intention was to move to the UK and to live here. That was the decision that the family made. But there is no evidence that this is what
they told the immigration officer that,
yeah. So I accept that.
Yeah.
No stamps, of course, are placed on the passports, but a public official makes a decision to admit them.
Well, that's again an assumption. There were no stamps on the passport, and they were helpful in Vassar because they gave us some insight into what was going on in the mind of the immigration officer. But when you say the immigration officer admitted them here, what do you mean by admitted them? He clearly allowed them to pass through the passport control. He didn't say get back on the plane.
Yes.
But what was he actually intending to do? What's the objective interpretation of what he's intending to do?
Well, admitting them under the regulations.
Why under the I don't understand quite why under the regulations. Have they asked to be admitted under the regulations?
Well, they arrive in the UK with their passports with an Italian residence card. And they say nothing to the immigration officer. They're allowed to enter. And the question is, well, how do we know that that was an admission under the regulations? It could be leave to enter. In my submission, it couldn't be leave to enter or remain under the Immigration Act 1971. And therefore, it has to be something else.
Sorry, so it couldn't merely be leave to enter? Why not?
It simply it couldn't be leave to enter or remain under the 1971 Act. The reason for that, I may have to come back to you on this. That the reason for that is in Section 4 of the Immigration Act 1971, which I'm afraid you do not have in the bundle, but I'm simply answering the question. I'll come back to that. So Section 4 of the Immigration Act 1971 says, it sets out how power to grant leave to enter or remain is exercised. And that section makes it absolutely clear that the power can only be exercised by notice in writing. And this court has made it absolutely clear on quite a few occasions that issuing of a notice granting leave to enter or remain is not a subsequent step. It's not that the Secretary of State decides to grant leave to someone and then issues notice. Issuing of notice is grant of leave to enter or remain. Therefore, and there is no notice granting leave to remain. So it is
Granting leave to enter or remain.
leave to enter or remain. Yeah, indeed. So therefore, the court can and should, in my submission, proceed on the basis that this was not a grant of leave to enter or remain.
But if it was admission under the regulations, why didn't he stamp the passport?
Yeah.
We know there's a stamp.
Yes.
We know there are two, one in Luton Airport and one at the Garden Ord.
Yeah. So so you do not have a provision that is equivalent of Section 4 of the 1971 Act in the regulations or in the directive. So it is, as a matter of law, possible for an immigration officer, and of course I'll come to the regulations in due course, I'm just simply answering the question, it's possible for an immigration officer to admit someone into the UK without placing a stamp on their passport.
You'd have to ask two things. One, did he have a right under the regulations? Because if he had a right under the regulations, then that might well be explain why the officer let him in. If he didn't have a right under the regulations, and if there isn't a stamp saying admitted under the regulations, that weakens the case for saying what must have happened was admission under the regulations. And then you would have a strange state of affairs, a black hole. It's not likely that he came under the regulations. We're saying it's not likely that he was granted leave under the 1971 Act. So one does wonder what was happening.
Yeah. So one thing in my submission that the court can be certain of, which is that no matter what it wasn't a grant of leave to enter or remain because of the operation of Section 4 of the 1971 Act. It just wasn't. And what was it then? And my Lord asked the question, well, was there a right under the directive of entry? If there is, then that explains. And if I say that, yes, there is a right, then my Lord will ask me, of course, that, well, why there is a right. So the way I put the case is this, that, and I will, of course, develop this when I take you to the remaining paragraphs, is that the immigration officer had a discretion. So there was no automatic right of entry into the UK. a person who comes to the UK with a passport and a residence card issued by an EU member state has no automatic right to entry. The immigration officer could have said, well, I am not admitting you into the UK, you have no right. The immigration officer had a discretion to admit, and the immigration officer had exercised that discretion and admitted the appellant into the UK.
Where did that discretion come from? Is it a discretion under the regs?
Yes. And I will, of course.
So you say that if that discretion is exercised, then the consequence of that is that although the individual had no right as a matter of EU law, discretion's been exercised in his favour and he gets the whole package, he gets a right of residence here.
Yes, so, lady, may I ask you to approach this in this way?
Yeah.
So the appellants in Vasa had no right to enter the UK. They were not family members, they were extended family members. Their right to admission was subject to examination by the immigration officer. So to that extent, there is no difference between this appellant and the appellant in Vasa. The appellant in Vasa had no automatic right. He also presented himself at court, and the immigration officer makes a decision to admit him. But of course, in that case, there was a stamp in the passport, and the court knew that it was a decision under the regulations, for sure.
Because the stamp said so.
Because the stamp said so.
Yeah.
In this case, you do not have the stamp. So the court must decide, therefore, objectively, looking at the circumstances, what was happening, what was the decision that the immigration officer took.
Well, he might have been not doing anything. He might have thought mistakenly he didn't have to do anything, because he might, not being a very good immigration officer, have thought that the Italian card was enough. So he wasn't saying, I am a public official conferring a right to enter, certainly not a right to reside, but whether I like it or not, this man's got an Italian card and I can't stop him coming in. So it wasn't, I'm admitting you, I can't keep you out, might have been what was going on in his mind, I don't know.
No one knows that, of course. There's no evidence. Now, my submission is, and the evidence tells us, that the immigration officer looks at the passport, looks at the appellant and his brothers, looks at the residence card, now scan those documents onto a scanner and tells them, you can go. My submission is that objectively, the immigration officer was exercising a discretion to admit the appellant into the UK on the basis of the Italian residence card. So what immigration officer could have said to the appellant, that you have no right, as the immigration officer in Vasa could have said to Mr. Vasa that, well, you have no right.
These are two separate cases, and we must, I understand entirely why you're building your argument on Vasa, but this is this case.
Indeed.
And what if the immigration officer just made a mistake and thought that the appellant was entitled to come in when he wasn't?
So it's entirely
There's no exercise of discretion. There's just a mistake.
Yeah. So entirely possible that it is a mistake, but and that is something that is discussed later in the judgment. My submission is that if an immigration officer admits someone in error by mistake, that is still a valid admission.
I think what you're sort of saying is there's no room for a mistake. Because once an immigration officer says, they either say yes or no, and that necessarily engages their decision-making powers. And so there isn't really room for mistake analysis, because it must be, if they waved him through, that a decision was made to let him in.
No, there is, milady, indeed a room for mistake. My submission is that that is inconsequential. It matters not. Milady, approach this with respect in this way, that, and this happens now and then, that the Secretary of State grants leave to remain to someone by mistake. It's an appeal that was heard 3 weeks ago. It happens. So the courts have said that, well, you grant leave by mistake, that is a valid grant. what you can do is you can rectify the mistake. You can say that I made the mistake and I'm taking the decision back.
But this is the other way around, isn't it? Because what you're saying, I think, is there was a mistake, and from the mistake, or it might be said there was a mistake,
Yeah.
and from that you can infer that a decision must have been made to let the immigration officer was, even if he was mistaken on the basis of allowing the person in, he still let the person in. So it's not the same thing as saying, as Vass was a case where there was a communicated conclusion that you've got leave to remain under the, or leave to reside under the
Yes.
regulations. This one is not that. This is different. Nothing is said, but you're inviting us to draw the inference that there must be within that a decision that was made, an exercise of discretion in your client's favour.
Yes, I mean, I have to, of course, and that is the case. So you can go, in my submission, is a decision.
Do we have one thing that might cast some light on what the immigration officer thought he was doing was if we saw the passports of the brother and the appellant, because if, for example, the Italian document, supposed to be in Italian, wouldn't it, says Mr. Appellant living with his brother and so on, or if it shows the dates that they were living in the property, that might show some light on things. Can you see what I'm driving at?
Yes, so we have a copy of the residence card.
Because it was referred to in the evidence, and it was in the documentary evidence before the tribunal, I think.
It was.
And I mean, what I'm trying to do is wonder whether the immigration officer would link the brother as living with the appellant.
Yes.
Thank you very much.
Yeah.
I haven't put that as well as I might have.
So if you, of course, it's printed on both sides, and you'll see if you look at the document that this
It's
is.
in English and Italian.
Yes, it is English and Italian.
Oh, and his motive, the type of permit, is family.
Yeah.
Oh, and well, there's nothing opposite dependent family members, though, is there?
Yes, on the other side. Yeah.
Oh, I see. So that's the immigration officer would have known that he was a family member.
Yeah, and he evidences that they both arrived together, and their passports, the appellant's passport is stamped when he left Italy, but of course that doesn't matter. But on arrival, an immigration officer checked their passports, scanned them, did not stamp the passport, and said to them, "You can go." Said to both of them, "You can go."
I'm in danger of getting confused, but this says that he's a family member, and what we're dealing with, I think, is extended family members.
Yeah.
So
So-
for domestic law purposes, we've looked at it differently, don't we?
No. So extended family member, for the reasons that I will explain, is a family member. So this is the residence card that in my submission is issued to family members and to extended family members. Of course, you'll hear more about that in due course. But so the domestic scheme, lady, as you observed a few minutes ago, is that if a UK residence card is issued to someone, then that person is treated as a family member. So the task of the court, of course, is to see, well, there's a residence card which says he is a family member. He comes with the Italian national brother together. The immigration officer says to them, "You are admitted." What was their decision? Lady,
And the last thing on that, do we know what the brother said? Because, of course, they might be, I mean, I know this is silly, they might have been coming to do sightseeing in Manchester for all we know, or they might have been attending some Italian or Pakistani festival in Manchester. So is there anything about what the brother said he was coming for?
No, my lord, no. And of course, they had decided to move to the UK in 2019, but there is no evidence that this had anything to do with
But that's the problem, is because, I mean, if an Italian national turned up at Heathrow prior to the departure of the United Kingdom from the European Union and produced their Italian passport, you wouldn't ask them anything more.
Yeah.
You'd let them in and you wouldn't say, "Are you here for a visit?"
No, you don't.
Or "Are you intending to work?"
No.
and if they had a family member in tow, they'd let them in as well. So it doesn't show facilitation of residence. That's the point. I mean, they may be letting them in as a family group. You get that out of this, but I'm wondering if you can go further and say, let them in as a family group for the purposes of living here.
Yes, but what was it? I respectfully invite the court to consider. I mean, if this wasn't an admission as a family member, then what was it?
It was admission as a family member, but for what purpose? For a visit, an extended visit, or to live here?
Yeah, I see that. That, my lord.
No, in Vassar, because it was stamped regulations.
Yes, but yes, my lord. That it matters not. I say with respect. Lord, may I just show you the subsequent analysis
Oh, yes, sir,
in
we're
Vassar?
still in Vassar, yes.
Just to make the points good. And so you have looked at paragraph 57. The next question is, and the question that, my lord, you asked links to the question that you are considering at paragraph 58. The next question is, what rights and benefits did the decision confer upon the appellants? And my lord notes that the stamps are a record of a decision that they were allowed to come into the United Kingdom and live with their respective relatives, who was a member of EU National. You don't have stamps, but in my submission, that is the effect of the words "you can go." A decision made verbally, in my submission, is as good as a decision made in writing. My lord, then consider the submission that Millennium Friend made that, well, this was simply an admission. So the stamps had admitted to the UK, and Millennium Friend said, well, that is not facilitation.
Of residence.
Facilitation of residence, because admission could mean, well, simply admitting someone. And my lord says that that is unrealistic, that what the immigration officer was doing is to let the appellants in, to require them to leave immediately. So whatever this immigration officer did when he said, you can go, of course, it couldn't be his decision that, well, you can go simply to come back to leave immediately. So that is the first point that is made. The second point concerns the stamp. So Milady asked the question that, well, what happened here could be a mistake. That is the question that is considered in that paragraph. For these purposes...
Which paragraph are you in?
Paragraph 59,
yeah.
Milady, just against letter G.
Thank you.
For these purposes, it is not relevant whether the immigration officers were mistaken as to the facts. For example, there was no dependency or membership of the same household, nor does it matter whether the immigration officer made error of law as to the scope of their powers. A decision was made, and even if it is a decision that is wrong, it is still a decision.
Mm. Yeah.
And that, in my submission, is no different here. My lord then considers a point that Millennium Friend made, that, well, immigration officers cannot have been given the appellant right to reside forever. And this, I think, was the point that troubled my lady, that, well, the immigration officer makes a mistake. Well, that means that, well, you're here, and even if you don't have a right. And that was the submission that Millennium Friend made in that case. My lord answered that submission in this way, that objectively interpreted, they were admitted to the UK as long as they satisfied the substantive requirements, i.e., as long as they were dependent or members of the household. Well, this is how I respectfully invite you to approach this case. When the immigration officer said, you can go, that meant that their residence was facilitated as long as they met substantive requirements. Well, here, of course, the evidence and the finding is that they were a member of the same household. They lived together in the same household when the application was made. And then, Milady, if you, in particular, Milady, if you look at the way that paragraph ends, the Secretary of State at no point decided to revoke the grant of admission. Rather, the legal framework changed, and the issue is to be decided is now admission under the withdrawal agreement.
I mean, there's no, just pausing there, there's no possibility in this case of a revocation of a decision because there was nothing to say that a decision had been made. So it's a very contrived proposition. I can see that if you make this, if you write down admission under the EEA regulations, it is possible to revoke that decision. So that analysis works. Here, that's quite difficult to see how that could happen, even if the Secretary of State did wake up to the fact that a mistake had been made. How do you revoke something that was never articulated? Point one. The second thing, which troubles me about Vassar as well as this case, is that if mistakes underpinned decisions in both of these cases, those mistakes are being relied on to grant substantive rights of residence, and I'm troubled by that analysis. Because there's case law of the European Court, isn't there, to say that if you make a mistake, you don't get a substantive right to a lot of it. It's just a mistake.
Yes.
So if you could help me with that, how we get around that corner, I would be very grateful.
Well, I think the answer to the second question is, in my submission, rather straightforward. I say that with respect, which is that this judgment is binding. Of course, the facts are different, but what the legal principles, this is binding, and this court must proceed on the basis that a mistake is of no consequence.
I think perhaps a more subtle way of putting it, and might have been in the mind of Louis L.J. there, was that things come first.
Yes.
Whether they should have come second, and the first question is what happened, and what happened is they let them in, stamp their passports and so on. So that's what happened.
Yeah.
And what the Secretary of State was doing is saying, well, it shouldn't have happened, and therefore treat it as if it never happened. So it's not that mistakes are being used to generate rights. Decisions are being used to generate rights.
Yes,
and if people are trying to defeat the decision by saying they shouldn't have made the decision, it is a mistake for them to do so. That's what I'm sure you want to say.
Yes, yes. Very grateful. Lord, and again, this say this with, of course, respect, that this is entirely consistent in my submission with the jurisprudence on mistaken grants of leave to remain. The courts have consistently said that a mistaken grant of leave to remain is a valid grant. And the way to is a valid grant.
So the way the Secretary of State should deal with it if they make a mistake, I think, you say, is that they revoke the thing that they've given. And then you've got sort of public law safeguards around that.
Yes, so yes. So if a mistake is made, then the Secretary of State has all the ammunition that she needs to rectify that mistake. So that is in my submission the answer to the second question that Milady you asked. The first question, Milady, is that that Milady asked that there isn't a written decision here. There isn't a stamp in the passport. So how do you revoke a decision that is made verbally? I don't know, but in my submission, approach it in this way, Milady, with respect that, well, a court makes a decision, says that the appeal is dismissed or the appeal is allowed, and no, there isn't a written decision. A verbal decision taken by a judge is as valid as a written decision. Even if there is no order, if Lady Milord, you say after hearing submissions that the appeal is dismissed, the appeal is dismissed. Even if an order isn't issued for many days, and if I come back to you tomorrow and make a submission that, well, you got it wrong yesterday, and there is a point that you haven't considered.
The oral decision
Yeah.
is just as revocable in principle as if it was
It is,
written.
it is,
So
yes.
It's entirely open to the Secretary of State to say, although nothing was said,
Yeah.
if a decision was made, we
I
hereby
revoke it, yeah. Yes. Now,
So the way it would work is, say he doesn't get his resident status for the documentary issue, the officer would turn up at the house in Rochdale and say, I'm here to remove you. And he would say, you cannot. I have been admitted by an oral decision of the immigration officer. And then the person says, well, very well, I hereby revoke that oral decision. That's how it happened. That's just so I got clear. I mean, I put the facts grammatically, but you know what I'm saying, is that it would work, it would become relevant if attempts were made to remove him, or if he attempted to come back in, having left, for example, to go see his wife and children in Pakistan.
yeah.
If they attempted to remove him or to not let him back, his statement would be, I've been admitted.
Yeah.
They would say, where's the document? And he'll say, there wasn't a document, it was oral. And they'll say, either we don't believe you, or they'll say, we do believe you, but we're revoking it. And that would be the way to deal with it.
Well, in principle, yes. Well, in principle, yes. But whether that would matter on the facts, it's another question. So if, for example, residence has already been facilitated and it is then revoked, that may have a consequence. But in principle, my lord, yes. So the Secretary of State can issue a letter saying that, well, you were admitted into the UK. I refuse you admission because I made an error. And here is a decision, a letter saying that you're not admitted. But for the purposes of an exercise of discussion by the immigration officer, a verbal decision, in my submission, is as good as a written decision. Paragraph 62 of the judgment, my lord considers Article 10.2 that a person falls within the scope of that article whose residence was facilitated by the host state. And my lord says that this is what happened in this case. Their residence was facilitated by acts of the immigration officers, acts of the immigration officer. My submission is that what my lord meant is the act of admission as opposed to the act of placing a stamp. And here,
they've got to get the EUSS statement, because you said it's not a grant of leave under the 1971 Act. They've got to get the resident status under the EUSS, haven't they? What happens if they don't get the EUSS statement? Say you lose on the document point. What would be their position then? They can't rely on any admission under the 2006 regulations, can they, once those have been revoked? They've got to switch to the new status, haven't they?
yes,
Yeah.
yes.
Sorry, yep.
Yes, and then my lord considers the other question, which is question 2 in this appeal, and I'll address it separately. My lord comes to the conclusion that a document issued by a relevant authority is not a residence card. A stamp is a document. Now, one may, of course, think that, well, a stamp isn't a document that is issued. I mean, when you refer to a document being issued, stamping of a passport is not something that would come to your mind immediately. A document that is issued ordinarily is a letter or
That's why you read
passport.
document in context. And you go back to Article 18 and
Absolutely.
you're looking at what they meant there, and what they meant was that thing
Absolutely.
that brought about a situation where the person was allowed in international law, and that thing in the United Kingdom was a stamp.
Exactly. So the point that I'm emphasizing is that a stamp is not ordinarily a document that is issued, but my lord said that it is a document because my lord read that word in the context in accordance with the purpose. The purpose being, if you have a right that has been facilitated, then you should keep that right. And this is the purpose that I would respectfully invite you to bear in mind when you'll consider the second question. But if you go to the next page, page 665, you'll see that my Lord says, rejecting the submission that the Secretary of State makes, the submission that my learned friend made was that, STEMP is not a document. And my Lord says that the reference in the legislation to in accordance with the national legislation means simply recognition of the legal act, legal act or decision, conferring the right to reside. So, and I place emphasis on the word or. So my Lord is saying, legal act or decision. So what the immigration officer did, was that a legal act? In my submission, it was.
I think with respect to misreading
you are,
64, 65, the very subtle argument that Ms. Smythe advanced was that it can't be in accordance with national law if there'd been a misinterpretation of national law.
Yeah.
And I was saying, no. It wasn't meant to be in accordance with national law properly applied. It was simply meant to remind us that the rights come from national law for extended family members, not from EU law. So I don't think you can perhaps put as much weight on that phrase as you're doing.
Yes. So I have no difficulty with the way you summarize those paragraphs. The reason being that my learned friend, you'll hear from her in due course, makes the same submission before you. But my Lord is saying that in accordance with national legislation does not mean in accordance with national legislation properly.
Applied, yeah.
It simply means in accordance with national legislation. So
it means a national act, not a EU act.
Yeah. That means that you're not sort of reviewing the basis of the decision to grant you residence, to facilitate your residence, whether it was in error or not. It doesn't matter as long as it is in accordance with national legislation. So even if the discretion is exercised wrongly or improperly, that is still an exercise under the national legislation.
I just want to run, you may say this is going off in a direction, but I struggle a little bit with these paragraphs. And I just wondered if anybody had considered whether the analysis was something more domestic, which was that whatever had happened in Vassar, the immigration officer had written something that gave rise to a legitimate expectation on the part of the individual that they had some sort of right, whatever it was, and that the analysis really was then to look at what was the scope of that legitimate expectation, how should it be measured, because whatever had happened, it really hadn't happened under national law because it was patently a mistake. But the whole point about legitimate expectation is that's a protection to the individual, quite often when the state is acting under mistake and it has done something wrong, but the individual has, been misled or has, But did anybody look at that?
No,
but you weren't in this case, were you?
No, I wasn't. But this isn't a legitimate expectation point. I mean,
it wasn't taken as that, but I'm just trying to work my way through it.
This simply is how you construe Article 10.2 of the directive. What is meant by facilitation in accordance with national legislation? Yeah. And now, what will assist my lady? I'm sure is that if you look at the text between E and F at that page, focus of the withdrawal agreement, and that explains the point. The focus of the withdrawal agreement was the rights under EU law were protected after the end of the transition period, the rights granted under the relevant national legislation acting under national law. So if there is a right, and that of course is a big if, the court decides whether there is, then the focus is to preserve that right, to protect that right.
Yeah.
I think perhaps the answer to my lady's concerns is 68 and 69 if you work backwards.
Yes.
There were decisions in Vassar, so the court found, the decisions to admit. It may well be that those emerged from a mistaken understanding of the regulations by the immigration officers, but they were a decision. Read the passport. And as had been administered law for years, if there's a decision, if you can hold something up and say, look, I've been given this right, then you assume it's a right until it's set aside or revoked.
Yeah.
And that hadn't happened here. But the first question is, what rights? And the second problem is, even if he had rights, if they've got to be translated into the resident status, then you've got that problem.
Yeah. So paragraph 67, and this is again a submission that Millen Friend makes. You'll hear the same submission. Millen Friend relies on an authority from an EU law authority. Millen Friend made a submission that stamps were not sufficient to confer rights because the rights are derived by the legislation, and you'll see that that argument failed as well. And then Lord, paragraph 68 and 69. That the decision that was taken was not challenged at any point. And in my submission, that is as good as a verbal decision. So if for example, an officer who is allowed to make decisions, or a judge makes a decision in court verbally, then that is a decision that is valid, unless it is deemed as invalid, challenged. So you can go, in my submission, was a decision that was a valid decision. And you'll see from paragraph 69 that my Lord says that that decision has not been challenged, and therefore the purpose of the scheme is to preserve the residence that has been facilitated. So this is, my Lord, this is Vasa, and you have, of course, seen the key provisions of the directive within Vasa. But may I show you just one other provision in the directive. The directive is behind tab 3 of the authorities bundle. And Article 3, as my Lord, my Lady have seen, is at page 129.
Just before we get there, can I just, I'm just writing a note to myself. So Vasa was a national law decision to admit. Yep.
Yes. And my submission is that here too,
The same.
it is the national law decision to submit.
And it has to be a national law decision.
It has to be.
Because extended family members
Have
don't
no
have
automatic
rights under the EU law.
Yeah.
That's the whole purpose of them
Absolutely.
needing a national decision. Yeah.
So it was perfectly open to, as I said, the immigration officer to say, to exercise discretion differently, say that, well, you can't go.
Well, he should have told them not to come in, actually. He should have told them to go back
Yeah.
and make an application for an EU family permit. And if he'd been helpful, he'd have given them the web link to the form.
Yes.
Because they don't accept paper ones.
Yes.
But he didn't. He said, you can go.
You can go, yeah. So he could have said you can't go, but he said you can go. So the document, so you have the directive, you have seen Article 3, Article 2 already, so there's no point taking you to those articles again. But may I show you Article 10, which you have at page 138 of the bundle. So this concerns issue of residence cards. And you'll see that the right of residence of family members, and this includes extended family members as well.
Why did you say that?
Yeah, because, my Lord, if you read that article in full, you'll see that this will become absolutely clear. Because if you look at Article 10.2e, it refers to Article 3.2a. So there can be no doubt at all that family member, for the purpose of this article, includes other family members. And in Article 10, a document is issued to family members and other family members. So right of residence of family members shall be evidenced by a residence card. And for the residence card to be issued, member state shall require presentation of the following documents. And E, in cases falling under Article 3(2)(a), a document issued by the relevant authority in the country of origin that they are dependents or members of the same household.
Right. So if you look at what this is, the right of residence of family members of a union citizen who are not nationals of a member state shall be evidenced by the issue of a document called residence card. So this is about the state, in this case Italy, issuing a residence card to people in Italy.
Yeah.
And then you get to E, and again, it's based on documents issued, because you can really only work on documents. So you know exactly what the status is, and you're expecting documents of some form to be issued.
Yes.
So this is saying that a state must give to people within its state a residence card if they can show the document issued by the relevant authority in that state.
In that state. So, yeah, exactly. Now, well, Italy has its own national legislation about which, of course, I know nothing. But the point is that in accordance with Article 10 and in accordance with the national legislation, Italy issued this residence card saying that this appellant is the family member of any national. So this is Article 10. Now, why is it that this appellant...
So for Italy to have issued this residence card, which we have looked at, Italy must have been satisfied of the point of E.
Yes.
Yes, yes.
So it must have seen a document issued by the relevant authority in the country of origin, that's Pakistan, isn't it? Certifying that they're dependents. Have I got it right?
Yes, but I mean, it's possible that there could be a slightly different requirement in Italy's national legislation.
Yes,
I don't know.
There is an obligation on the Italians. If he turned up, if the appellant turned up in Rome with the relevant documents, the obligation on the Italian state is to grant a family, to grant a residence card to evidence that fact.
Yes, but
but this still presupposes that the Italian authorities have given him the right of residence, doesn't it? Because he doesn't have the right of residence otherwise.
No. So, just to answer Milady's observation, it is theoretically possible that there could be a provision in the domestic legislation of Italy relaxing...
It might be different or broader.
Broader, precisely, relaxing this further. Now,
but this doesn't give you the right of residence in Italy, even if you've got the Pakistani statement of authority.
Unless this card is issued. So there is no right of residence in Italy.
And there's no obligation to issue it because it's evidence of a right of residence. And the right of residence is, in the first instance, for the Italian authorities. They decide. They may say, we're not having any dependents.
Absolutely. Yeah, I have no difference.
And that's case law tells us that whatever Article 10 says, there's been some words since that say it's all to do with domestic legislation.
Yes, precisely. But it matters not, of course, because we know that Italian authorities exercise their discretion, issued a card.
So he has a right under domestic Italian law to stay
Live in Italy.
Italian law, yes. And he's a domestic Italian law to stay in Italy. That's what he's been given the right of. And that Italian domestic right, because it's been the facilitation of an extended family member of a union citizen, they've got to issue an evidence-based document showing that the Italians have given him the domestic law right to live in Italy.
Yes. Why they have done so, of course, it's not a matter. It doesn't matter.
It's up to them.
Yeah, it is for them.
Do we need to just put in a caveat here? Don't I remember something from the Secretary of State's skeleton to say that none of this applies anyway because the brother was an Italian citizen, so you don't get into European stuff at all. So there is just that overlay we might have to deal with.
Yes, but my submission is that it matters not. It is a matter entirely for the Italian authorities.
Fine.
They have issued...
They've issued him with a residence card.
So it is not, in other words, for the UK to say that a person does not have right of residence in Italy.
No.
No, but it may be that it's a bit of a distraction to look at Article 10, because it may be that it's not a European right. It's a domestic law. For whatever reason, the Italians have given him a right of residence in Italy.
Yes, but
That's as far as it goes.
Yes, but my submission would be that this is an Article 10 document.
Well, we'll need to hear.
Yes,
from Mrs.
if it is not, then what is it? Then I don't, in my submission.
I think what says it might be another mistake.
But the lady, it is.
It may not matter.
No, yes, and it is. If it isn't an Article 10 document, then it is not in my submission for the appellant to explain what is it. I mean, if the Secretary of State says that this is something else, then the Secretary of State will needs to persuade you that this is something else. And if my learned friend,
But how does it help, assuming that this is something that the Italians thought they had to issue and did issue under Article 10, how does it help us in England decide what the position is? I don't quite see why we're going to Article 10.
Yeah.
no, simply in my submission for showing that a residence card is issued under Article 10, essentially, perhaps to provide context of the next submission that I'm making. Now, why is it, my lords and my lady would be wondering, why is it that this appellant decides to come to the UK with his brother with Italian residence card? Why did he not apply in Italy for a UK residence card? Why would they simply book a flight and come? The answer to that is in a guidance document that the Home Secretary had issued, which you have at tab 19 of the bundle. So this is what the government is saying publicly to people. This is the guidance that was enforced at the relevant time. It has been amended. It says entering the UK as the holder of an Article 10 residence card, this residence card. And see what the Secretary of State tells the public, someone in Italy, that from 1st of January 2022...
Where are you reading from? Oh, yes,
Sorry.
top,
Yeah. From 1st of January 2021, you would no longer be able to use Article 10 cards. Of course, prior to that, you could use an Article 10 card to enter the UK. But after that, you will need a valid national passport with EU settlement status, family permit, etc. And then see what is said under heading Article 10 and 20 of the residence card. Well, Article 10 residence card, the Secretary of State says, is a card that is issued by member states, evidencing the right of residence. A non-EEA spouse to a French citizen who is living and working in Italy may be issued with an Article 8 residence card by the Italian authorities, not different from here. And then Article 10 residence card should feature the wording, residence card of the family. This is the wording that appears in the residence card that you have looked at. And then the guidance says that if you have this card, then click this link and make the application while you're here. This is what this appellant did.
where do you say? I'm not with you. Where are you reading?
My apologies. So you've seen the middle of that page,
Yeah.
which says Article 10 or 20 residence card. So this is where the policy tells us what a residence card, an Article 10 residence card is.
Yeah.
It should say residence card, a family member, a union citizen. You then see the next heading, applying for an EEA family permit or an EU settlement scheme family permit. So this is all about telling people that, in my submission, that you can enter the UK.
Doesn't it say these applications for free of charge will help you facilitate your entry into the UK?
Yes. So, yeah. So, yes. So, if you hold an Article 10 card, you may be able to apply for a residence permit. And the applications are free of charge and will help facilitate your entry to the UK. And then there are two links. And of course, if you read that in the context, of course, the policy is saying that, well, after 1st of January 2022, we know that is the relevant date. You can't use Article 10 cards to enter the UK, and you should do this if you want to come.
Well, we need to get your submission exactly. It seems to be an extra. But what this says...
No, this is the entire policy.
This is the entire... Oh, gosh.
This is the entire policy.
All this says, to anyone who reads it, there's no evidence that your client read it, but all it says is from the 1st of January 2021, you can no longer use an Article 10 or 20 residence card to travel to the United Kingdom. You can no longer use a card to travel. It doesn't tell you anything about rights or things like that.
No.
And you would have thought that if you're going to up sticks from your country where you're living to go to another country, it doesn't look as if relying on that, you can no longer use it after that date, would be seen as you can rely on it to give you residence.
Yeah.
And then if you go down a bit, you'll see the bit saying you've got to get an EEA family permit, or talks about getting an EEA family permit or EU settlement scheme. And if you look more into that, you'd have realised, oh gosh, yes, having a residence card from Italy doesn't help necessarily. I can travel there, but it looks as if I've got to have more. Yeah. So what is your submission about this and Article 10? How does it help us in this case? Just remind me.
No, my submission is that this helps us understand what happened on the date in question when the appellant arrived in the UK.
So 2019 before this. So
no. So this is 2019 before the date that you have. Yeah. Yes. But this helps us in my submission in understanding what has happened. So what this implies in my submission at least is that prior to 1st of January 2021, it was open, possible to a person with an Article 10 residence card to travel to the UK. Yeah. Of course, as my Lord Justice Lewis points out, well, this isn't a sort of firm basis. It says nothing about rights, and I do not suggest that it does. But
you can travel to the UK.
Travel to the UK. In my submission, well, take your chance. The immigration officer at port can say to you, well, no, you can't go in. You got to go back, make the proper application. Or the immigration officer can say, well, you have entered the UK before 1st of January 2021, and you can go in and make whatever the application you want to make. So I'm not saying that the appellant has any right arising from this document, but simply it provides the context in which my lords, my lady will construe what happened on the day.
Well, it gets to be helpful to hear what Miss Mai says about that box at the top, why that one's there, not now, but when it's her turn.
Yes. So finally, if I may then take you to the regulations.
Well, before we do that, are you going to take us actually to the wording of, because assuming you're right so far, you'll tell us whether you're relying on Article 5 or 11 in due course. But leave that to one side. Assuming you're right so far, and there was a decision, assuming in context there must have been a decision, you can come and live with your family members so long as you meet the family member requirement. Assuming all of that, just talk me through, when the regulations have been repealed, you've got to apply for a residence status. So you can't rely on the original decision. You've got to get a residence status document.
Yes.
And for that, you really do have to meet the requirements of Article 18, or at least the member state can require them. And you didn't have the family permit or the residence card under the regs.
Yes.
And you didn't have a stamp. So your case really, and we perhaps should look at Article 18EL, really does come down to treating a verbal statement, you can go, as a document issued by a national authority, does it?
My Lord, as I said at the outset, so what I hope to do is to address you on two questions separately.
Okay, you still want to stick with question one, right?
Question one, so I'll just conclude.
We'll come back to that later.
But of course,
you will be taking us to 18, whatever it is.
Absolutely. So I have to sort of overcome that problem, of course, to persuade you to allow the appeal. It's not enough simply to show. But you have seen Valerian Friend's skeleton argument. She makes point about Article 18 at the end, in a single sentence. Or in a single paragraph. Her real argument is about Article 10.2. This is where that is where the controversy is. So that is why I'm spending more time on
Okay,
that.
as long as we haven't lost sight of it.
No,
I wanted us to go to the regulations.
So regulations, tab 4. Again, my lords, my lady, you have seen the relevant provisions in VASA. If you look at page 166, this sets out, this is regulation 2, it sets out certain definitions, and you'll see that the regulations define what an entry clearance is and what an entry clearance officer is. And it also defines what is a residence card. So a residence card.
Can you give me a page reference? My fault.
Yes, page 166.
Thank you very much.
At the end of that page, a residence card means a card issued under Regulation 18. So, well, hence the difficulty, and so I cannot say is that, well, an Italian card is a residence card. If it were, then we would not be in this problem. So a residence card means a card issued under Regulation 18. And if you then look at just the second half of that page, there is a definition of qualifying EEA residence card, which is our card here. A qualifying EEA residence card means a valid document called residence card of family members issued under Article 10 by an EEA state to a non-family member as proof of the holder's right of residence.
The non-EEA family member.
So the appellant. The appellant is non-EEA family member.
So EEA national. That's the brother.
That's the brother.
Okay, and then we have the issue about whether he's an Italian citizen or not. Okay.
Yeah.
Yep.
So the document that you have seen in my submission is a qualifying EEA state residence card. It is not a residence card.
Yeah, and it shows he's got the right to reside in Italy. Whether it's right or wrong, that's what it says.
No, yeah. Exactly. Now, what is it that was happening on 12th of December 2019? The answer may be in Regulation 29, and I'll take you, of course, back to Regulation 11 because that is referred in Regulation 29. So this is the procedure in relation to EEA decisions, and this is the procedure that in my submission the immigration officer was following on 12th of December 2019. So this regulation applies to a person who claims a right of admission to the UK under Regulation 11. We will look at Regulation 11 in a minute. But as a person not being an EEA national or appellant who, Roman 5, is in possession of a qualifying EEA state residence card. So a person comes to the port with an EEA relative, and that person is in possession of a qualifying EEA residence card, then that person falls within Regulation 29. He is seeking admission. This is what this appellant did. And what is it that the immigration officer did? That is that you will see from paragraph 2. The regulation says that the immigration officer shall treat the person as the person was seeking leave to enter. And then the 1971 Act provisions apply in Schedule 2. So this is where the immigration officer has the power to examine documents, look at the passport, speak to the person if they want to, decide whether to allow them to enter or not.
Well, hold on. That last phrase, decide whether to allow them to enter or not.
Why?
I don't know, we haven't got 2, 3, 4, 7, 6 to 18A and 21 to 24, and I haven't got Feeling Gillespie. So are you saying that one of those paragraphs is a paragraph that says the immigration officer will decide whether or not to allow somebody to enter? Because all this says, if the person doing this regulation applies,
yes.
person seeking entry on the basis of a qualifying ECD shall be treated as a person seeking leave to enter the United Kingdom for the purposes of paragraphs 2, 3, 4, etc. And then you went on to say very quickly, and to decide whether to admit. Is that something that's in paragraphs listed there, or is that a gloss?
No. So, Milord, if you read 2A, and you'll see that the reference in paragraph 2, I'll tell you what the paragraph 2 is that the immigration officer may examine the person who arrived in the UK, is to be read as reference for the purpose of determining whether the person is to be granted admission under these regulations. So you come at port. It is not in my submission necessary for the court to look at Schedule 2 for this reason, that this tells us that when a person comes at port, he is not an EEA national but a family member. Then the immigration officer examines him for what purpose? To decide whether that person is granted admission under these regulations.
So I think we're at cross purposes. I think this is just a provision giving you all the procedural rights you need. That you look at the passport, I don't know whether there's a detention right and so on, but all that says is you have all the rights for somebody claiming to come in under Regulation 29 that you would have if it was a non-EE case, somebody coming from Japan or the Cameroons or somewhere. That's all it's saying.
My submission, my lord, is that this isn't something that confers any right. So that isn't the point that I'm making, my lord. So this confers no right on the appellant. This, as the heading says, is the procedure. So this will assist you, in my submission, in deciding objectively what happened on 12th of December. Not that, I'm not suggesting, and I emphasize it again, I'm not saying that the appellant had a right of entry. No. The appellant presented himself claiming, essentially, seeking entry into the UK.
It tells you what the procedure was that the immigration officer was following.
Yes.
He'd have the powers under
Yes.
2.
Yes.
Why?
Yes.
Because he's deciding whether to admit you, and that's a key, you say, to what the immigration officer thought.
Exactly. So if the appellant had entered without EEA residence card, then this regulation would not have applied. But he entered the UK in possession of a residence card, and the immigration officer was deciding, after looking at the card, whether he should be admitted. And this explains when the immigration officer says, you can go, this is the discretion that the entry clearance officer was exercising. This was the procedure that was being followed. So when the immigration officer said, you can go, the immigration officer was exercising, in my submission, a discretion under 29(2) and saying to the appellant that you can go, I'm granting you admission.
So put forward, he said, I hereby certify that I have exercised my powers under those paragraphs. I've decided that you can go. That is, you can be admitted to the regulations. That's what you say the context was. Must be, because that's what the procedure is.
Yes.
Yeah.
Yes. So, and this is the discussion. Now, this regulation then refers back to Regulation 11, which you have at page 174. And this concerns a right of admission to the UK. And I have conceded, I say it again, that there's no right, there's no automatic right that the appellant had. But this says that an EEA national must be admitted, no question about it. But a person who is not an EEA national must be admitted if that person is a family member, and family member of an EEA national produces a valid passport and a qualifying EEA state residence card, then that person must be admitted.
But this person wasn't a family member.
He wasn't a family member because he was not issued with a UK residence card.
And he's an extended family member. He's in Regulation 8, not Regulation 7.
Well, hence, there was no obligation to admit, but there was a discretion to admit. A person who is not an EU national must be admitted.
Sorry, this transposes EU law, doesn't it?
Yes, it does.
And EU law doesn't confer discretion. It allows member states to decide the question.
It allows member states to decide whatever they want to do in accordance with their national legislation. When it comes to extended family members, there is an obligation to admit. There is no obligation here. But in my submission, that does not mean that there is an obligation not to admit.
No, but if there's no obligation under 11, he's not admitted under the regulations. He can, of course, always be admitted under the Immigration Act.
No, but for admission under the Immigration Acts, you got to grant leave to remain by notice in writing.
Yeah, and they didn't.
No. So
Those are the two powers. You have Part 2, which gives effect to EEA rights. It's not giving a discretion for national law outside EEA rights.
yes.
If you're outside EEA rights, that's when you have to go to the Immigration Act.
Yeah. But we know for sure in my submission that this you can go is not a grant of leave. Millennium Friend would not submit that it's
but
grant.
it doesn't mean that you can go was also the exercise of discretion under Regulation 11. Regulation 11 doesn't confer a national discretion. It implements an EU obligation.
Look, my apologies, and I'm not suggesting that it does.
Oh.
I'm saying that there is an obligation to admit. The discretion to admit in my submission is in Regulation 29(2).
Forgive me, I need to go back a step. Regulation 11 requires a person who's not an EEA national to be admitted if that person meets certain criteria, but that person must be a family member of an EEA national.
Yes.
And this appellant is not a family member. If I got this right, he's an extended family member, so it's in a different category.
Subject to one qualification, yes, which is that an extended family member is to be regarded as family member if they are issued with a domestic residence card
It's not
In
that
this
case,
country.
in this country. So we are
he
not.
could have become a family member for domestic law purposes if he got his
Yes.
EEA qualifying, UK EEA
Absolutely.
qualifying card.
So, exactly. So, if in 2019
Yeah.
he had applied for a residence card,
A UK resident.
the UK residence card, you'll hear more from Learn Friend, but in all likelihood, he would have been issued with that residence card. And then he wouldn't have been in the problem that he is in now.
And
He
he
didn't
would.
apply, sorry.
Sorry, can I just finish? Because I'm a bit confused
Yeah.
about this. So then he would have been a family member for these purposes.
Exactly.
And his entry would have been required.
Exactly.
So what I really wanted just to ask you about was little 3 of 11. And forgive me, this is probably very familiar territory to you, but it's not familiar territory to me. So that's when the immigration officer must not place a stamp on the passport
Yes.
of the person who's admitted.
Yes.
So that would be somebody who's not an EEA national, but that person produces a residence card. That would be the UK residence card.
Yes.
A derivative residence card. We haven't talked
Whatever.
about that.
Yes.
A permanent resident, or a qualifying EEA state residence card.
Yes.
Did the appellant, I thought we talked about his Italian thing, was this being a qualifying EEA state residence card?
Yes.
I thought that was that.
It is. Yes.
So if he did have that, I'm just wondering if 3 is the answer to what the immigration officer probably thought here. He didn't put a stamp in, he said he can go because he produced this thing.
Yes.
And was he right or wrong? And he was wrong to do that, was he?
The reason, yes, the reason. Well, he was probably wrong, if I may just put it this way. The reason being that you'll see 3 says admitted to the United Kingdom under this regulation.
I see.
And this regulation
So that
means.
refers back to what we've just looked at, which is the definition of family member,
Yes.
which has certain requirements.
Yeah. So it is entirely possible that the immigration officer was thinking that, well, I need not to place a stamp on the passport because of this.
The way it works, I think, was that EU law granted certain categories of people certain rights. And very early on, there's a reference from the Pontypridd Magistrates Court, and they said you can't put stamps in passports of EU nationals, because that will make them think they're there at the behest of the state, where they're not. They have a right under EU law. but you've got to be admitted under Regulation 11, and this person was not admitted and could not be admitted under Regulation 11, so that didn't prohibit placing a stamp in his passport.
Yes, yes. But why is it that the immigration officer did not place the stamp in the passport? We don't know for sure, but this probably explains.
But it may have explained it because he may not have read the words under this regulation carefully.
But my sort of bringing this to a closure, the first question, my sort of broader submission is that EU law, when it comes to extended family members, has left the matter to the member states. They have a wide discretion. They decide, whether to admit them, how to admit them, when to admit them, what is the criteria they apply. And my submission is that the immigration officer, pursuant to that wide discretion, facilitated the appellant's residence.
This is quite important. There are two layers of activity, the EU law and the national law. And we're concerned with the person who, by an instrument, has got a right to reside here.
Yeah.
EU law does not give your client a right to reside in the United Kingdom because he's an extended family member within Article 3.2. So even if EU law allows member states to have their own laws, their own national laws, you've got to identify those national laws. And Regulation 11 doesn't amount to a general discretion. It gives specific rights to specific people. That's the difficulty that
I know, and I thought hard about this. So the way I put this, and I completely understand. So where is the discretion? You should ask under.
Show me the rule that says, and you may also, even if you don't meet 11, come in.
So there isn't a provision in Regulation 10 that says so. I accept that, of course. But my answer with respect is twofold. The first being that discretion is under Regulation 29.
It's a residual discretion, you say.
Exactly.
Yeah.
That is the first point that I make. The second point is that there is a discretion implicit in Regulation 11. But that, of course, is an alternative point. My primary submission is that it is Regulation 29. Because, yes, there is an implicit discretion to admit, but primarily Regulation 29 too. So, and for these reasons, I submit that this person falls within the scope of Article 10.2. And this is because his residence was facilitated by the immigration officer on 12th of December 2019. That was before the end of the transition period. And Article 10.2 requirement is therefore satisfied. Then the second question, which is about Article 18. Which isn't.
So before we turn to the second question, that means that a lot of what the upper tribunal said was wrong then.
Yes. So
At some stage you'll just take us to that and you'll show us which paragraphs are wrong. Don't do it now, do it when it's convenient.
yes. So I was hoping to address you on the second question and then at the end.
And then do that, yeah. So you want to do the second question now, which is Article 18.
I think in this case, both sides say that the upper tribunal got quite a lot wrong.
Yeah.
But ultimately, these are questions for the court.
Yeah.
So question 2, Article 18, and I, before I take you to the withdrawal agreement, I again flag that isn't the real controversial issue here. You'll hear from a learned friend, but her submission is really about Article 10.2. So withdrawal agreement is tab 5.
Yeah.
My apologies, it's not. It's tab 6. So if you look at page 221, you'll see Article 9, which has certain definitions. you will see that the phrase family member is defined. And you have seen Article 10 already, which is at page 222, and you have heard submissions on what it entails. So I'll take you straight to Article 18, page 225.
Sorry, just to be clear, 221, the family members fall in the scope of Article 10 are the family members in 1, i.e. those in 2.2. It's the direct descendants. It's not the extended family members.
No.
Yeah.
No. And hence, my lord, and I will explain, my lord said that extended family members are not family members,
Yeah.
but they are other persons.
Yeah.
Now, if you go to page 225, and you have Article 18. You look at the opening words of Article 18. It says, the host state may require Union citizens or United Kingdom nationals, their respective family members. Now, these are not extended family members. And other persons. And my Lord Justice Lewis said in Vasa that other persons include extended family members like this appellant. But there is a distinction in the withdrawal agreement between family members and other persons. And this person is other person. So this is how Article 18(1) starts. You will then see that applying for such residence shall be subject to the following conditions. And the condition that is relevant for our purpose is L, which is at page 226. You'll see an immediate contrast in the language of L and the language that is used in the opening words of 18(1). 18(1) said family members or other persons, but L says that host state may only require family members. Family members, not family members and other persons.
Well, it says that, but it can't mean that, because read the whole of it.
Yeah.
It's clearly a shorthand mistake. The host state may only require family members who fall under point E1 of Article 10(1), family members properly so called, or Article 10(2) or 3, and those are the extended family members who've been facilitated or have applied for facilitation. So although they leave out the words other persons, they must have meant them, otherwise half of it doesn't make sense.
Okay. So that means that the alternative submission that I made in my skeleton, it's not a point that, my lord, you'll accept, but I have made a submission.
Sorry, I've forgotten that.
Yeah. So if you have my skeleton, paragraph 37 of my skeleton argument.
But do you see the point I'm making?
I am, yes, and my lord has with respect to an entirely valid point. I do not have an immediate answer to it. So my skeleton argument, my lord, if you have the bundle.
Oh yes, yeah.
Paragraph 37.
Yeah.
So the submission is that, well, there's got to be a reason why the phrase other persons is not used. My lord, Lord Justice Lewis in Vasa said that extended family members are other persons, not family members.
Yeah.
So the submission is that it's questionable whether this applies to other persons.
Yeah.
But then, of course, I have the problem that, my lord, you identified.
Yeah.
So I make my primary submission at paragraph 36. So you construe this, and this may, at first blush, seem a submission that isn't an ordinary submission, but if you consider it in the context of the purpose, you'll see that it would make in my submission more sense. But the submission is that the word issued has two meanings. The first meaning is to publish something, issue a letter, issue a decision. But that is not the only meaning. Issued also means to make something known formally, or to make known or announce. And the submission is that Article 10 residence card was a document, and the immigration officer formally made it known that the United Kingdom accepted and adopted it as a document under Article 3.2.
Hold on. So even though it wasn't issued by the relevant authority, it was a piece of paper issued by somebody else, on this occasion the Italians, but it was formally adopted and thereby issued and became the document under which you had rights under English law.
Yes. Now that I accept, of course, requires some mental gymnastics, but what would justify it is the reasoning of my lord in Vasa. If you are with me, of course, this is a big if, that this person's residence was facilitated, then in my submission, you got to conclude that the whole purpose, the scheme, is to protect that right. And it is, in my submission, inconceivable that Article 18 was intended to exclude a person whose right of residence has been facilitated in accordance with the national legislation. That was the reason why my Lord Justice Lewis said that, well, stamp means issued, a document. So if you construe the word issued with that purpose and focus in mind, then in my submission, the submission wouldn't look as surprising as it would if you look at it in isolation. That
Doesn't
is...
matter that on that analysis, if the immigration officer had simply waved them through and said nothing at all, you'd say the same thing. You could infer from that was a permission to enter, and that must all amount to a decision. Is that right?
Well, not necessarily, probably. But I mean, if I'm making a submission to a judge and a judge, nods the head, that may implies that an order has been made, but not this case. So I wouldn't say that. Well, if nothing is said, I mean, probably it is still a facilitation, but that not this case. So perhaps. I mean, that question may arise in another case, but here, the only evidence which the Secretary of State does not seek to counter is that immigration officer said you can go.
What you're really saying is we mustn't be hung up on the words documents issued by a national authority.
No.
What that is, because the whole agreement was drafted in a world where we do have nationality and residence proved by documents, what you're really saying is a shorthand where the state has let somebody live there, it's got to be protected.
That is the reason why Millennium Trend is absolutely right to deal with this at the end of a skeleton in a paragraph or so, or in a couple of paragraphs, because Millennium Trend, in my submission, would know that if I'm right on the first issue, if the residence is facilitated, then it would require quite a lot of justification to say that you are excluded from Article 18.
And you can test it in this way. The whole thing is to look after people who've been allowed to live in the United Kingdom, know that it's not part of the European Union. If immigration officers routinely said, do come in, do stay here, we don't have any paperwork in this country, we're not that kind of country. And if 10 years later they turned up and said, you were fools to rely on us, you needed a document, yes, we let you in, yes, we were happy to walk you through the border, but you're out now. And you say that's not what the purpose is. I've elaborated it in my Welsh way, but that's what you're saying, really.
That's
is what that phrase was meant to do, is to capture the act of admission, not the requirement of a document.
Exactly. So this really, with respect, ultimately, the real issue in this appeal is whether you can go, those words construed objectively mean that the immigration officer was admitting the appellant into the UK in accordance with the national legislation. So finally,
Very odd though, because you said that for domestic things you've got to have a notice in writing, For EU things, you've got to have a document. But here we have a situation where you've got neither of those, but it's all right.
Yes, and if yes, and if this isn't, well, if the position is that this isn't a grant of leave, this isn't an admission, then what is it? And Millennium Friend in my submission would bear the burden of explaining to you what had happened. Finally, may I just show you the upper tribunal's decision. So the remade decision is at page 89. And if you look at page 94, you'll see paragraph 16 simply summarizes the evidence. If you wish to see the witness statements, they are in the bundle. The appellant entered through the Manchester with his brother. When he left, an exit stamp was placed. On arrival, the immigration officer scanned the passport, the residence card, and said, "You can go," and no stamp is placed on the. But this is the only evidence that is before you. There is discussion about what was written on a boarding pass. Visa okay at gate, but I place no reliance on it.
And it's dealt with in paragraph 60, actually.
Yeah. Yeah, so and the analysis starts at paragraph 38. The upper tribunal gave four separate reasons for dismissing the appeal. The first reason that is given is at paragraph 49. Paragraph 49, the point is that the appellant was not relying on a solely domestic law provision. He had been issued with a residence card. His admission was therefore governed by the directive as implemented by the regulations. It poses no difficulty to the argument that I make. The fact is that the directive was transposed into the domestic law by the regulations. And you have my submission that it was a facilitation. The second reason the upper tribunal gives is at paragraph 51. And the point is that there is no stamp in the passport, and that the appellant was only admitted for 3 months. I have no difficulty with that either. But the admission wasn't for 3 months. In my submission, it was for as long as the appellant satisfies the substantive requirements. But even if it was for 3 months, that is still fine, makes no difference to the argument that I make, because he made the application within 3 months. That would still mean that his residence had been facilitated. The third reason is at paragraph 52. That the appellant's entry and residence to the United Kingdom had been facilitated by the United Kingdom in 2019. That, I say, is correct. This was pursuant to directly enforceable EU law and not solely in accordance with the national legislation. That with respect, is wrong. It's difficult to see what enforceable EU law right this appellant had. It was surely in accordance with the national legislation, but even if it wasn't, you'll see that the upper tribunal has inserted words solely. It is in principle possible for a person to be admitted, his residence to be facilitated, both under EU law and the domestic legislation. And a sole facilitation under the national legislation is not a requirement.
Can I go back to the first one, paragraph 49?
Yes.
the upper tribunal judge was saying that it was done under Regulation 11, implemented by Article 5, implementing Article 5, and therefore it is EU law, not national law. And you say that's wrong insofar as it was Article 5, but it was under the regulations, either under Regulation 29, or it was an implicit national discretion
Yes.
in Regulation 11. So
Yes.
it's a subtle reason why he's wrong, I think.
Yes.
Is it? I've understood it correctly.
Absolutely,
Yeah,
Lord,
okay.
you have. I'm very grateful.
So that's the third reason. And then the fourth,
The fourth is at paragraph 53.
oh yes,
That the initial right of residence expired long before the end of the transition period. There was no intervening application, let alone a decision. At the end of the transition period, there was no facilitation. There are three different answers. The first is that the appellant was not admitted for 3 months. He was admitted, as my lord puts it in Vasa, for as long as he met the substantive requirements, namely for as long as he remains a member of household. Second, even if he was admitted only for 3 months until 12th of March 2020, that is 3 months from 12th of December 2020, he made his application to the Secretary of State on 20th February 2020,
Yes, okay.
the first application.
was
But
that
it does,
refused, though?
which is refused, and he then makes another application that is refused. But in my submission, it matters not to the analysis. The third point is that the upper tribunal.
No, I'm sorry, doesn't it? Because I'm trying to remember Chelik again, where he made different applications at different stages, but he didn't challenge the first one. So it has to be continued in accordance with the national legislation. So he'd have had to have something to continue it. And if he applied and the application was refused, then he didn't have a national right to, and I think Chelik said, he'd have to have appealed the first one, and he didn't.
Yeah, so the way I address it is the third reason. So you fall under Article 10.2 if your residence is facilitated by the UK in accordance with the national legislation before 31st of December 2020, the answer is yes. The second is that you continue to reside in the UK after 31st of December 2020. Both conditions are met. So,
No, I'm sorry, it doesn't say that, though, does it? I mean, that's why you've got to look at the regulations. It says continued in accordance with.
yes, yeah.
In accordance with us, provided they continue, so it is just continue to reside. Okay, yeah.
Yeah, so well,
Do we have the letters in the bundle? I couldn't see them. He made 3 applications, didn't he?
yes.
Be quite useful to see the letters.
I will, my lord.
Okay,
May I
Anyway,
just
so,
have-
so that's your first reason is he wasn't admitted for 3 months. Secondly, if he was within 3 months, made an application within the 3-month period. And then thirdly, if in fact he continued to reside, that's enough for Article 2.
That's it. So what the upper tribunal is doing here, and what Melanchthon does in her skeleton, is to insert words in Article 10.2 that just do not exist.
Yeah.
So you're inserting words and facilitation continued until the end of the transition period. Those are not the words that appear in Article 10.2. And if the authors of the withdrawal agreement had intended there to be another condition of that sort, they would have said so. The 2 conditions are met.
Yeah.
So these 4 reasons in my submission are either flawed or do not answer the point. And then the 5th reason concerns Article 18, and that is at paragraph 58. Again, for the reasons I have set out earlier, the upper tribunal dealt with that very briefly in a sentence at paragraph 58, that well, even if you fall within the personal scope, Article 18 would not apply. But if I'm right on first question, then surely it would, for the reasons I have given. So this is the upper tribunal's decision. In my submission, it is wrong in law. There is a finding, if you wish to take a note of it, that the appellant yes, paragraph 66. They were members of the same household at the relevant time. It is questionable what happened thereafter. Is not relevant. They were member of the same household. So this is the Upper Tribunal's decision. My Lord, if you wish to see the earlier decisions, may I just show those decisions to you? So if you go to page 217 first. You will see the first decision, page 218. The first decision, that is 5th of October 2020. And this is the refusal of the 20th of February 2020 application.
So he came December 2019, didn't he?
December
2019.
12th of December 2019.
Yeah.
Made
He
the
applied in February, yeah.
applied on 20th of February, within 3 months, and this is the first decision. And the reason in my submission is evidently flawed, of course, if you accept the submissions that I've made. The Secretary of State is saying that, well, where is the residence card? Where is the UK residence card? You don't have one. And that means that your residence has not been facilitated. You don't meet the requirements. Just final paragraph at page 218. The Home Office records do not show that you have been issued with a family permit or a residence card under the regulations. And for that reason, you don't qualify. But we know from VASA, of course, that facilitation does not mean issuing of a residence card.
But it did go on to tell him to apply for one, didn't it? In the middle of page 219, in order to meet the definition, you need to have it. And if you want to submit an application, go to those links.
Absolutely. So we wouldn't have been in this problem if he had simply clicked the link and had applied for a residence card. If he had, you'll see from page 219, then in all likelihood, he would have been granted a residence card. So when
Why didn't he then? Why didn't he? Do we have any evidence?
No. I mean, he wasn't legally represented. He just felt that, well, no, there is no evidence.
No evidence.
Why he did not apply. His brother got it, and he just felt that he would make another application.
Would he have could he have made it in the UK, or would he have had to leave the UK?
No, in the UK.
Yeah.
In the UK. I mean, so all you had to do is to click the link, apply for a residence card, and you'll get it for sure, because it's highly likely that you'll get it, because you're a member of the same household, you're living together on the findings made by the Tribunal. There is an Italian national card. Once you have the residence card, then that's it. Then you qualify under the USS.
So was the threshold that you were just living in the same household, or was there a dependency?
No. So it's either dependency or membership of the same household. But for the mistake, he's
we don't know why. It may not have been a mistake. I mean, he might not have wanted to click that card because he might have thought, oh, I don't actually meet the dependency. We don't know what went on.
No, we don't have evidence. Simply answering the question, my Lord, that you asked.
He didn't challenge the decision. If he's not legally advised, he wouldn't have thought, well, I'm not prepared to do this form. I don't need to. So he might not have challenged this on that basis. More surprising that he hasn't clicked the link. But anyway.
Yeah. I mean, he could have, of course, appealed against it on the same basis that he has appealed the latest decision.
Yes, because it's exactly the same, isn't it?
Yeah. Yes, but I mean, you asked the question. I answered it that this was a mistake. He wasn't legally represented, and he just felt that make a new application. The second decision, the decision of 9th of December 2020, is at page 200. And you'll see that the application is refused virtually for the same reason. A copy of the decision that you have seen. The Secretary of State says, well, you haven't got the residence card, you don't qualify, that's it. And we know again from VASA that a residence card is not essential. The third refusal is at page 184. The reasons are at 186, 187. Again, the same reasons are given. And you'll see that there is now no longer an advice that he can apply for a residence card, because this is after 30th of, this is April 2021.
Has the scheme been withdrawn?
Yes. And the final decision that is subject to these appeal proceedings is at page 154. And again, same point, that you do not have a residence card.
Page?
Page 156. So the decision starts at 154, but the reasons are at 156. Last paragraph, you do not have a residence card. And this time, the appellant brings in an appeal. There is a right of appeal against earlier decisions as well, but this is the decision that is appealed. So, my lords, lady, unless I can assist you any further, these are my submissions.
That's very, very helpful. Thank you very much, Mr. Malik.
Good.
Very patient as you've taken us through these provisions. Right, so Miss Mai.
My lords, my lady, you'll have seen our respondent's notice. Just to be clear, that sets out in summary form what we say is the correct legal analysis. It's at page 41 and 42 of the core bundle. And the court will see squarely at paragraph 2.1 is that he wasn't entitled to a residence document pursuant to Article 18.1 because he didn't hold a document issued by the UK. So I'm going to answer my learned friend's case in 5 stages, and I'll summarise the 5 stages now. So stages 1 and 2 are that the appellant had no right of entry to all residents in the UK under the directive or EU law. And that's for 2 separate reasons. Reason 1 is that his brother didn't enjoy any rights under the directive in Italy because he was in his state of nationality. So to cut a long story short, for reasons I'll develop, that puts paid to any reliance on Article 10, including under the domestic legislation. I'll explain why. The second is that even if he'd enjoyed extended family member rights under the directive in Italy and had been granted a residence card, if, for example, his brother had been a French citizen in Italy that still wouldn't result in him having any right of entry to the UK. So although Mr. Malik hasn't suggested there's a right of EU law, under EU law, because of various arguments he makes, I just need to make that clear what the correct position is under EU law. So that's points 1 and 2 of the analysis. Point 3 is that he also had no right to be admitted to the UK or to reside here under the 2016 regulations, and nor was there any discretion to admit him, whether under Regulation 29 or otherwise. That's the third plank.
Yeah.
The fourth plank is, unlike in Hassanaj and Faza, there's nothing here which is capable of satisfying Article 10 or Article 18 of the withdrawal agreement. Now, to be clear, I agree that Articles 10 and 18 should be read together, but that works against Mr. Malik, not for him, because both require a document. So he said twice, I think, a decision made verbally is just as good as a decision in writing. Well, even taking his case at its highest, it's not, for reasons I'll explain, because both Article 10 and Article 18 need a document, and they mirror one another in that respect. So that's the fourth plank. And then the final point I say I don't need, but it's my alternative analysis, that even if there had been some facilitation of residence, it had ended before the end of the transition period, and that is what the upper tribunal found. And we do say the upper tribunal got it wrong, but ultimately the outcome is right for the reasons in our respondent's notice.
And what's the relevance of it ending before the transition period?
Because we say that what Article 10.2 requires is not that at some point in the past you've been facilitated as an extended family member and then hung around unlawfully. What it requires is, as at the end of the transition period, your residence was as an extended family member. That only comes up if we get there, which I say we don't, but that's why.
And you'll tell us at some stage what he did do with this immigration officer, because he clearly allowed him to come in.
I think all I need to say is that he made a mistake either as to the facts or as to the law. Whatever it was, it doesn't get Mr. Malik over the hurdle that he needs to get over.
It may be that what he did was the result of a mistaken understanding of the facts or the law. But what did he actually do?
Well, he let them pass through border control. That's what he did.
Were they here unlawfully?
Yes. Now, one needs to be careful here, because one would certainly say that having come in that way, the reality is that they're going to be given time to make the application that they need to make, the same as somebody who enters on an EEA family permit. But that didn't happen here. So if the Secretary of State had turned up, I think they entered on which date it was in December, was it the 19th, the 12th?
12th.
So if the Secretary of State had turned up at the door on the 13th of December, one might think the appellant would have said, well, hold on a minute, Secretary of State, your immigration officer let me in yesterday and here I am typing out my application.
But strictly, when he completes that application, he's got to tell the authorities that he's here in breach of immigration law. So it'll be refused.
No, because it's a discretionary exercise, and the Secretary of State would take into account what happened at the border.
But strictly, once he got through the passport control, he's here now, but he's here unlawfully.
But it's not. Yes, something that is taken into account, as I recall from my dim memory, when the Secretary of State is deciding an extended family member application, is whether or not the person has been there unlawfully. But it's a factor to be taken into account. It's not a bar. It's not like under leave to enter. So there's a discretionary judgment to be made.
It is a negative factor in or it can be a negative factor in the exercise.
But it
just sounds odd that a man in uniform tells me you can go through, and I've shown him everything I've got, and I follow what he does, and he's in the Home Office, so we trust him implicitly, and I'm here illegally. I'm not committing a criminal offence, am I, hopefully, or am I doing that as well?
But that would all arise were he to seek to regularise his position, which he did, and he didn't like the answer. He was
Was he
told how
committing a
to
criminal
sort it
offence?
out.
Just out of curiosity, I'm just trying to work out what must have happened. Would he have been here illegally, in the sense of unlawfully, and also legally in the sense of committing a criminal offence?
I wouldn't want to ad-lib that. I'd need to check.
Need
But
to
the
check,
fact
yeah.
is that, as a matter of domestic immigration law, he was a person who needed leave to enter or remain and didn't have it.
Sorry, he did not have leave to enter or remain.
He needed leave to enter or remain and he didn't have it, is the reality. And perhaps to just, before I start developing my points, just to address a point that my lady raised, which is, well, hold on, in EU law, you don't have a right just by having a piece of paper. And similarly, you don't not have a right if you don't have a piece of paper. And one of the arguments I made in Hassan... Oh, and I should say, I'm absolutely not running the same arguments in Hassan Basra. I wouldn't dare. But what I am saying is that the argument I made there actually does bite here. The point is that under EU law, being given a bit of paper doesn't mean you enjoy substantive rights. And there's a case we've mentioned...
No, that sentence needs to be unpacked. As a matter of EU law, you don't have EU law rights. Simply because
yes,
it's a piece of paper.
That's exactly, but that's the point of distinction I'm going to draw. So the court has been shown Hassan Basra. I'm not going to turn up any authorities. Let me just try and explain it. The case that I relied on in Hassan Basra was Mr. Petraea. And Mr. Petraea got himself deported and wasn't allowed back for a certain number of years and decided that he would just come back anyway. And the authorities gave him a piece of paper saying he could come back, and he tried to rely on that, and the court said, well, you can't because you've been deported. Now, except that's not these facts. Similarly, in a case called Diaz, Miss Diaz was here with a piece of paper saying you're allowed to reside here until X date. But because, as a matter of EU law, and I accept that's a distinction, as a matter of EU law, she didn't actually have a right of residence. She just had a piece of paper. And the ECJ described that as illegal residence, I think is how they put it. So in other words, the piece of paper doesn't matter. Now, the reason I submit...
Piece of paper doesn't matter for EU law rights.
Exactly. So the reason that submission was rejected in Hassan Basra was because they had something under domestic legislation. So my Lord Justice Lewis said, well, actually, they've been granted something under domestic legislation and that bites, so we don't, the EU jurisprudence doesn't come in. But this case is different because there hasn't been something, we say, granted under domestic legislation. So we are assuming, for example, that an immigration officer made a mistake, and I'm sorry, this is quite a long answer to a question, but assuming the immigration officer made a mistake and thought two people were married, supposing in Mr. Chelik's case, Mr. Chelik, who wasn't married, had been waved through at the border, told you can go because the immigration officer thought that he was married and he wasn't. His position, once he wanders through the border, is that he doesn't have any right. The reason that it was different in Hassan Basra was because they had been given something. But we say this is more like the example I've just given, because the immigration officer might make a mistake and think that people are married and they've got a direct right of entry, but if they haven't, they haven't. So the distinguishing factor in this case is that nothing has been done under national legislation. In the same way, and when I say national legislation, I mean specifically, not just any old national legislation, but national legislation specifically implementing Article 3.2, and I'll explain why I make that submission. So that's really the difference. And so to address your Lordship's question, isn't that unfair? That is the consequence. It may be that some principle of domestic law steps in, but we're not in that territory here, because when the appellant did do something to regularise his position, he was told he needed to do something else. He didn't do it. So with that, and I
He
hope...
should have been told to go back to Italy, you see.
Yes, he should have been.
You shouldn't, if you're right.
Yes, he should have been.
Hold on, because on the first letter he was told to click the link, which he could do from within the UK.
Yes,
So he didn't do that twice.
he didn't do that.
And then the
twice.
transition period ends.
Yeah.
When he makes his next application, he's out of time to apply
Too
onto
late.
the EUSS.
Yeah.
And at that point, the letter should say, the only thing you can do is go back to Italy on your Italian residence card and
What-
apply for whatever it would be from there.
He can't do it anymore because we've left the EU.
That's true.
But what the decision letter wouldn't normally do is tell you how else you might sort out your immigration position. That's the point. If you've ignored 2 letters saying you might want to do this, that's the point at which to see a lawyer, and perhaps they might tell you to make a different kind of application.
But on your case, when the man first came to Manchester Airport in December 2019, one of 2 things should have happened. If you're right on your interpretation of the law of events, he should have been told, I'm terribly sorry, but you have to go back to Italy because you have no right to come here. But that didn't happen.
No.
He was allowed to come here.
Or,
So they must have been doing something.
yes, or he could have been granted leave to enter at the border.
He could have been granted leave to enter the border.
Yes.
Now, Mr. Malik says that's got to be in writing, and it's not enough to say you can go, you can pass.
That's right, although the point is exactly the same under the 2016 regulations, because that also has to be recorded by a document, we say. So it doesn't do to say, well, leave to enter would need to have been given in writing, so it must have been under the 2016 regulations. Incorrect. Also under the 2016 regulations it needed to have been done with a document, so that point's simply neutral.
Can the state waive the requirement? It's there for the protection of the state, presumably, requiring documents. Can the state waive the requirement that it be in writing?
But in principle, the state could do that for leave to enter as well.
Say you're at the border and usually the Home Office computers are down and they say, I'm really sorry, I should normally print this out, but I can't, but go through. Would that be a waiver? I mean...
Well, then that would depend what, I mean, I can't print what, I suppose, is the question. But we come back to my example about 2 people who turn up and the Home Office thinks they're spouses and lets them through even when we're in the EU. What is their right when they arrive? They still don't have one. And as I say, whether some principle of domestic law would step in at that point is another question. The point here is, it is unfortunate that there has been a mistake, but mistakes happen and then they need to be sorted out.
When you say there's been a mistake, that's a word that you're using to describe events. And the first thing we need to do is neutrally to describe what happened. And then when we've worked out what happened, you might like to call it a mistake. But we need to work out what happened first.
Well, I've got nothing to add, I think, to what's in our skeleton and what's been said and what the Upper Tribunal says, which is at paragraph 60 of the Upper Tribunal's decision, and my Lord Justice Lewis has already referred to that. And we respectfully adopt the description in I think it's in the Commission judgment or at the Commission hearing, which is he was allowed to pass through the border. In other words, he wasn't sent back, he was allowed to pass through. So he's got himself into the UK. But that's it, in the same way it would if mistakenly people were thought to have a right under EU law and they didn't. The position is what once he arrives, what then is his position? On the facts of Hassan Ajambaza, the position was the reasonable and objective interpretation was X. In this case, the reasonable and objective interpretation is not that the residence was facilitated. And I'm jumping ahead in my submissions as I answer the questions, but we say quite clearly it wasn't.
Yeah.
Whatever this is, and what in my submission, if one's trying to sort out something like this, and unfortunately, as this court recognised in YC, unfortunately mistakes are sometimes made.
No, I understand that, but we mustn't start by assuming there's been a mistake, and we must unravel what's happened. I'd quite like to work out what's happened first, what the immigration officer thought he was doing. And then we might say, or you might say, my goodness me, how could you do that?
Well, I think what I need to do is develop my submissions about the law.
We'll let you develop your submission, and then, but you know what's troubling us, yes.
Yes.
Ms. Smith, can I just go back a step? We had a discussion a few minutes ago about when the appellant arrived at border control, what the options available to the immigration officer were, and I've got noted but he maybe should have been told to go back to Italy and apply from there. Then I noted down that you said that he might have been given leave to enter
Yes.
by the immigration officer. What's that under? Because my next capture was that both the 1971 Act and the regulations require a decision about entry to be in writing.
Yes,
We know that
exactly.
didn't happen. So are there residual discretion? I mean, you may come to that anyway, but are we talking about that?
As I understand it, the option, and we'll check this at lunchtime, but the option would have been to grant leave to enter or leave to remain, and then that would be endorsed on his passport.
And that'll be under the Immigration Act.
Under the Immigration Act.
I see.
I don't think there's a third way.
Okay. So you say no residual discretion. I had noticed that earlier.
Well, certainly no residual discretion under the 2016 regulations.
And no, sorry, two separate points. Residual discretion and or the writing of it down. So you say he might have been given leave to enter or remain, possibly as an exercise of discretion, but that would have been
That
endorsed.
would need to have been written down, exactly. But certainly the way that the 2016 regulations are set up is not that decisions are made at the border. Rather, there has to be this stage of the Secretary of State positively exercising a discretion in the person's favour and considering it. And I'll show the regulations. The reason that that didn't matter in Hassanaj and Barzat was because my Lord Justice Lewis decided that if one looked at, no matter what the formal legal status was, one looks at the reasonable objective interpretation of what happened, and that, once one has the stamp, is as it is per the decision. But here, in my submission, it goes far too far to say the reasonable and objective interpretation is that the immigration officer had granted a right under the 2016 regulations to reside.
Well, the other interpretation is he seduced them to enter illegally, and I can't imagine the Home Office were encouraging people. I thought the Home Office was rather against people coming illegally.
It certainly is, but I'll make the point again that sometimes there are mistakes.
Well,
So that doesn't mean that the fact that there is a mistake made in respect of a third country national, for whatever reason, does not mean, in my submission, that their residence has been facilitated for the purposes of Article 10.
you're going back again to why he did it, not what he did. What did he think he was doing? Did he think, quite simply, that the man that stood in front of him was now going to be able to come into the United Kingdom and live there with his brother? Is that what he thought was going to happen?
I don't know what the immigration officer thought. I can't speculate. He may have made a mistake as to the law. He may have thought, for whatever reason, he had a direct right of entry. He may not have been concentrating. He may have had a...
Those are all explanations of what happened, and I'm still at the first stage of what happened, and I'm wondering whether, if you'd asked the immigration officer immediately after he said, you've just told him you can go, does that mean he can go and live in the United Kingdom with his brother? Would he have said, yes, that's what I meant? Now, you might then have said, well, how on earth can you say that? Don't you remember your training? You can't say that. But that's what I'm trying to get at first, is working out what it was that he was doing, or what, more accurately, a reasonable person would think he was doing, and then you work out the consequences.
What we said in our skeleton is he seems to have made a mistake thinking the most likely explanation is that he made a mistake for some reason, thinking there was a direct right of entry.
But did he think the person had a direct right to come in and live here? Is that what he was thinking? Is that what we think happened objectively? It wasn't just letting him in for a visit or anything. It was letting him in to come and live with his brother.
No, because one doesn't know what... I think my Lord made the point at the permission hearing. Maybe they were coming to see the Tower of London.
Yeah.
We don't know what was said. People pop to the UK from Italy all the time. And that reads in my submission far too much into what happened.
Well, should we let you develop your submissions? Because we haven't had, I mean, you've given us the 5 stages, and you haven't yet, to be fair, you had the chance to develop even stage 1, leave alone 1 to 5. But we'll try and let you develop 1 to 5 later on. So 2 o'clock?
What arises for April?